You wouldn't believe how many clients come to me after they've already made one of these mistakes. They thought it would be okay and the right thing to do to give a recorded statement or to post something on social media as an update after an accident, or even worse, to trust the tone of the adjuster. But every one of these mistakes can jeopardize your injury claim and cost you tens of thousands of dollars that you otherwise are entitled to. Hi, I'm Ted Spaulding. I'm a personal injury attorney here in Georgia. And for the past 20 years, I have spent looking at how adjusters take advantage of these mistakes to minimize payouts. And so what I'm going to do in this video is I'm going to walk through the 10 most common slip-ups and show you how to avoid them so your claim can be handled properly and you can be protected from day one. So let's jump right in to the first mistake: giving a recorded statement to the insurance company, and especially doing so before you talk to a Georgia personal injury attorney. See, adjusters will call you very soon after an accident, either the day of or the day after, and they'll sound friendly. They'll even sound like they are compassionate and care about your injuries and are here to help you. And then they'll ask, hey, we need to get a recorded statement for you to tell me your story of what happened. But here's the truth. Giving a recorded statement is not for your benefit, it's for theirs. See, adjusters are trained in how to give these recorded statements, how to ask questions a certain way to either get you to downplay whether you're injured or not, or to set up a situation where even though their client was ticketed for the wreck, that somehow they're not at fault or fully at fault. For instance, they might get you to say, well, I'm really not feeling injured right now or that badly. Or even worse, things like, I didn't see him coming before the collision. Those are horrible mistakes to make. They will then flip that around and use it against you weeks or months later when you're trying to resolve your claim. Well, you told me this in the recorded statement, and that's not what ended up happening. Now you're stuck. And see, in Georgia, you are not legally required to give a recorded statement to the at-fault party's insurance. Why give it if you're not legally obligated to do it? It is only for their benefit. We always suggest you politely tell them, no, I do not want to give a recorded statement. I will get you all the information you need, and we can go from there. Let me give you an example. I had a client in Atlanta who told the adjuster in a recorded call, didn't feel like she was really that hurt. Turns out she had a herniated disc and then needed surgery of all things down the road. Well, what happens when we go to try to resolve this case? What's the first thing the adjuster brings up? Well, Mr. Spaulding, I have a recorded statement from your client the day after the wreck saying she didn't feel any pain at the scene and she was okay. She wasn't hurt. Now all of a sudden she needs surgery and all this stuff, as if it's made up. And we had to fight through that. If she hadn't done the recorded statement, it wouldn't even been an issue. Mistake number 2 is settling for the very first offer made by the insurance company. This is one of the oldest tricks in the book. Adjusters know how to quickly get you to take an offer. See, they'll hit you when you're really not worried about your injuries. You're more worried about your property damage or how am I going to get a rental car in the day or two after the wreck. This is when they'll hit you with an offer. And here's typically how it works. They'll call you a day or two after and they'll say, we'll offer you $2,000 to settle your injury claim. Maybe that sounds nice. You've only had an ER visit. You haven't gotten the hospital bills or anything yet or the x-rays. But after hospital, medications, physical therapy, $2,000 is not going to go very far. Worst, once you accept and sign off on that kind of a settlement, you are forever done with your injury claim. You cannot go back. You cannot say, well, something has changed and now I'm owed more than $2,000. So that's not valid. No, it is legally binding. You are done with your injury claim at the $2,000. Now see, Georgia law allows you to recover all of your damages, meaning all of your treatment, all of your lost wages. Why would you settle early before you know what that is going to look like? That takes days, weeks, months, years even, sometimes when you're really injured, to know what your full bills are. How much did you really miss in work? But you settle too early, you can't go back and get a second bite at the apple. So let me give you an example. I remember a client of mine from Marietta had a car wreck. He was offered $1,500 the day after the wreck. Sounded great. He hadn't even gotten treatment yet. he did get treatment. We gathered all his medical records, calculated his lost wages. Those numbers equaled $20,000. Now, thankfully, he didn't take the $1,500. He hired us. We were able to settle his case for multiples of the $20,000 for everything combined, including pain and suffering. He would have sold his case, in essence, for less than 1% of what the actual value was had he taken that what sounded great offer the day after the wreck. The third mistake is waiting too long to see a doctor or not following the recommendations, missing appointments, those sorts of things. See, insurance companies, they will keep a close eye on when you treat, how often you treat, do you miss visits, all of that. And they will use any and all of it against you. When you take time, first get treatment, they love to call that a gap in treatment. Wreck occurred on one day, you didn't go see the first doctor for 5 days or a week. Or I've had clients that have waited a month to go see the doctor. Now, when that happens, they're going to argue that means you weren't injured in this wreck. If you didn't go immediately or same day, it couldn't have come from this wreck. It had to have come from somewhere else. Why give them that kind of an argument? So what you got to look at is Georgia law says you need to get prompt care. Doesn't mean it's the end of the world, but you're going to give them arguments. It's going to be harder to prove your injuries came from the accident the longer you wait. Why do that? If you're hurt, go get treatment immediately. Maybe you felt okay at the scene. That's fine. You wait till the day after to go. That's okay. But if you wait much longer, you're going to create some really, really difficult situations for yourself in trying to link your injury to the accident. Now, if you miss appointments, you don't go to physical therapy when told to, or you go the first time, but you skip the others, or you don't do that recommended treatment, all those things will be used against you as well. Well, you couldn't have been that hurt because you would have done this, is going to be the argument. And some of that is legit, right? Unless you have a good excuse for why you didn't do it, you feared a surgery. That's understandable. But physical therapy, doing shots, if you're asking for compensation for big injuries, but you didn't do what the doctor told you to do, most insurance companies are not going to believe you when you say, here's why I didn't do it, and it's legit. Don't miss appointments. Don't not do the treatment that you're asked to do. I once helped a client from Savannah who waited 4 days to go to the ER after her wreck. And what ended up happening is the adjuster argued, well, she must not have been injured from this wreck because she waited so long. Well, we finally were able to convince the insurance company and get the case resolved, but this caused a tremendous delay as they argued and argued and argued over whether this wreck really caused her injuries. If you're hurt, get checked out as soon as possible and follow all of your doctor's advice. Now, this one has become way more commonplace here over the past half decade to a decade. Mistake number 4 is sharing details of your accident, injuries, or recovery on social media. Facebook, Instagram, TikTok, any of these other platforms. Insurance companies are trained on how to monitor them and pull any relevant information. They're looking for anything that might contradict your claim, especially that you're severely injured and cannot have the same life that you did before due to these injuries. So maybe you're posting a photo from a cookout a week after the wreck where you're smiling with friends, or you're posting an update and from the gym. Even though you're not actually working out, you're there with friends, but it's showing that you're at the gym. Well, see, adjusters are really skilled at taking what you would think is a benign photograph, update post, a status post, and twisting it. Well, you were at the gym working out. Look at you smiling at a cookout or going on a vacation. Must mean you're not injured at all. You're lying that you're still injured. The safest rule, and what I tell everyone, is to not post at all after your accident to any social media, regardless of topic, until after your case is resolved. Why? Because you can post just you saying nothing, just smiling with friends at an event or going on vacation or taking a walk or anything. And they can use that picture to twist what it really shows and say, see, she wouldn't be smiling if she's really as bad off as she says she is. So I recommend that. Worst case, you don't post any photographs, any updates on how you're doing, and you only respond to friends, family, things like that, and what they're posting about. At least keeping it benign to what's going on in your life, what your status is, any of that sort of thing. Again, even a seamlessly harmless photograph can be taken out of context. If you're unsure, you want to talk to an attorney first before you do any kind of sharing. And again, you know my standard, which is just stay off of it. As difficult as it is, just wait until after your claim is resolved. The fifth mistake is skipping collection of evidence at the scene of your accident. And I get it. You're hurt, you're rattled, you're not thinking about these things. There's more important things that you're thinking about. But this is why I'm telling you, don't forget this. It is really important. Taking pictures, talking to witnesses. It can make or break your claim in Georgia. See, adjusters hope that you'll forget to do these things, that you'll forget to take photographs of both vehicles, the road conditions, any visible injuries that you have, or get information from witnesses. Because if you don't, it becomes much harder to go back later and get all of that evidence. The other driver's story may change. Evidence can disappear. Witnesses don't show up on police reports. You don't have their contact information. You didn't take it down. They're gone. So let me tell you about a story of one person I represented out of Augusta. And so she was rear-ended at a stoplight. Seems pretty straightforward. She was rattled. She didn't take pictures of her vehicle there at the scene, the other party's vehicle. Later, that other driver, instead of telling the truth and saying, yes, I rear-ended her at the stoplight, says that she backed into him. And without witnesses, pictures at the scene, where this occurred, how it occurred right there, the insurance company denied the claim at first, saying our insured's not at fault. It's actually your insured, your client that's at fault. Well, we got lucky and we were able to find security footage. And so she was able to still pursue that claim. We got around that, showed them that their insured was lying, but not everyone gets that lucky. Doesn't always exist. So in Georgia, having evidence like photos, witnesses, getting statements from them, all of their contact information so they can be found later, getting the police report, obviously, and taking pictures of any injuries and road conditions, massively important to protect your interests and ultimately what you deserve in your claim. Next, let's talk about a big mistake, admitting fault at the scene or to the insurance adjuster. In the heat of the moment, it's natural to apologize or even to say that you should have seen the other vehicle coming. The adjuster will seize on any of that information and put blame on you, deny your claim, saying you're liable given your statements. But here's the thing in Georgia. We're in a modified comparative fault state. What does that mean? That means that if you're found 50% or more at fault for the accident, you get nothing. Even if you're less than 50% at fault, your settlement would be reduced by the percentage of fault that is assigned to you. So you don't lose out 100% on your claim if you're less than 50, but your settlement or verdict will be reduced by that percentage that is placed on you. So if you say something like, I'm sorry, as if you're at fault, or I should have done this or that, the insurance company is going to say, you might not be fully at fault, but 20% fault because you should have seen them coming and avoided it and that sort of thing. Don't give that to them. So let me give you an example. I had a client from Columbus, Georgia, and all he did was he simply apologized to the other driver at the scene and said he said that to the insurance adjuster. And it was just his Southern manners. That's what we do. Hey, so sorry this happened. That sort of thing is what he meant. But the insurance adjuster seized on that and said he's clearly somewhat at fault if he is apologizing for the wreck. And therefore, we're not assigning 100% fault to our insured. So if you're in an accident, stick to the facts when talking to anyone. Don't say things like that, I'm sorry, or I should have done this or that. Give it time. Let the police report come out. And don't make those mistakes. You don't want to guess. You don't want to speculate. You should have done this. You should have done that. You don't know this. And you certainly don't want to admit fault, especially if you're not at fault. All right, mistake number 7 is going back to work or assuming normal activities before your doctor has said it's safe to do so. Remember, just like the prior mistakes we've talked about, you want to follow doctor's advice at all times. So, you see it a lot. Folks feel like they're doing okay. They've got 2 weeks till they have their follow-up with the doctor, but they know the doctor is going to say, yeah, you're fine to go back. So I'm just going to go ahead and go back now. Well, that's not what they said. They said, do not go back or don't do XYZ, lift a certain amount of weight or whatever until I see you again. Don't do it. It will be used against you later if you continue to be injured and you were wrong, or you went back to working out and lifted weights and re-injured. We don't owe you for any of that treatment afterward. So be real careful. If your medical records show you return to work against advice, they've got it in writing now. The doctor will note that. They have to, because they got to show they told you to stay out. You went back early. Now you're complaining of this. All in a medical record that they get to put up on a screen to show a jury. A medical record the adjuster will then throw in your face and say, we don't owe you anything from this day forward. You did not listen to your doctor. So let me give you an example. I had a client from Athens, went back to work. He was a warehouse worker, and he went back just a few weeks after a back injury because he didn't want to lose his overtime shifts. And that's understandable. But then his pain flared up because he went back to work early. Now, our argument is he needed surgery anyway. He didn't do anything going back that would have further injured it. But they've got the argument. Here's what he was complaining before. It's all in his medical records. He's doing well. Supposed to wait another week, goes back. Now all of a sudden when he shows back up to the doctor, he's saying it's flared back up. Well, that flare-up's not caused by us, and then therefore that future surgery he ends up having is not because of us. If he hadn't gone back to work, he wouldn't have needed that surgery. So you see how all this can create really difficult arguments. We were successful in arguing through that by using the doctors and everything else, but it created a ton of litigation, years of delay just because of that argument that they had. And a whole bunch of money, by the way, and having to disprove that somehow that work scenario caused the need for this surgery versus the actual wreck itself. So don't give this to them. Follow what your doctors tell you to a T. All right, mistake number 8 is not keeping a record of all your accident-related expenses, big and small. Now, we will get, any attorney in Georgia will get all your medical expenses. So that I'm not as concerned about, including prescription costs. But there's other areas. So the adjuster is counting on you to miss these small or even big things that aren't going to show up in a medical billing record. What are your other expenses that you might have? That could be crutches, bracing, modifications to certain things. Sometimes the house has to be modified if you're in a wheelchair. Your vehicle has to be modified so you can get in and out. Having to take Uber rides because you can't drive. All of these kinds of things can add up. And the adjuster, they're not going to take into consideration unless you give it to them. Here's all my Uber receipts. I spent over $1,000 having to take Uber because I couldn't drive. Or I had to modify my home, and here's a $5,000 bill to do that. They're hoping you're not going to present it to them. If they don't, it's as if it doesn't exist. See, in Georgia, you can claim all these out-of-pocket expenses as part of your damages, and a lot of people don't think about them. But you need the proof, so you've got to keep receipts. I tell people, keep a folder, everything you get related to the accident, bills that come in, expenses, credit card receipts when you go buy gauze, okay, or a wrap. Keep all of that. It's harder to go back later and recreate all of it and remember what you did and didn't do than to keep it as you're spending that money. So let me give you an example. I had a client in Roswell, and she lost out on thousands because she forgot to keep track of her mileage going to and from physical therapy. Now that's simple. We could kind of try to fudge that and look at the mileage and figure some of that out. But oftentimes she would get that and then have to go get the prescription and then go back. So there was extra mileage there that she missed. And then she also missed, she needed crutches and then ultimately a brace for her elbow. She got those at CVS, but we couldn't find, she paid cash for it. So we didn't have a receipt. We had to try to use other evidence, and it just makes it a mess. So she ultimately just had to let those things go because we didn't have the proof. Don't let that happen to you. Mistake number 9 is an easy one, but it often happens. Don't miss the filing deadline. In Georgia, you generally have 2 years to file a lawsuit before you forever lose your rights. You don't want to wait until a month before or even a couple of weeks before to call an injury attorney. That's not enough time to get it together. You have got to make sure a lawsuit is filed or you will forever lose your rights. Adjusters know the law. As you're starting to get close to that statute, all of a sudden they're going to be ghosts because they know it's coming up and they're hoping that you don't know. And you're just waiting for that phone call back. Oh, well, I was waiting because we were trying to work it out. And then all of a sudden I couldn't get in touch with them for the last month. Well, yeah, because they knew the statute was about to run. Don't let them do that. 2 years in almost every case. And talk to a Georgia personal injury lawyer early to make sure you know exactly what the statute of limitation is for your particular case. All right, lastly, mistake number 10 is trying to handle everything on your own without legal help. Insurance companies like to deal with people without attorneys because they know that the average person doesn't know all the things that we just went through, and they can stumble and make mistakes. They can miss deadlines. They can not get all the evidence that they need. They could forget all their damages and not present them correctly. They don't know how to ask for policy limit information, so they don't have to give it to them. There's a Georgia statute on exactly how to force the insurance company to give you what is the policy limit in the case. They won't tell you otherwise without legal help. See, a good Georgia personal injury lawyer knows all these tactics by the insurance companies. They know how to fight back and how to protect your rights. We can estimate what your claim is worth. We can talk about what the deadlines are, things that we need to get evidence-wise. And then we can also pursue the best settlement possible to try to avoid having to file a lawsuit. And that way you don't get paid less than what you're actually entitled to. It's so very important. I've seen so many Georgians miss out on fair compensation because they waited too long to get help. Don't make that mistake. Even just talking to a lawyer, you don't necessarily have to hire them. Call a Georgia personal injury lawyer, get some legal advice. It's free. It can help you. And then you can make a decision, do you need to hire them? Now you know the 10 mistakes that insurance adjusters are hoping that you will make that can destroy your claim. Be smart, be cautious, and protect your rights. If you found this video absolutely interesting, I hope you did, I want you to watch our next video. You must see it. It's called 4 Types of Damages You Can Pursue During an Injury Claim. It covers the real money you might be entitled to, and most people have no idea what's possible. Click on it now and don't miss out on what you are truly owed. I'll see you over there.